Thank you for joining Jackson Lewis as we take a closer look at the employment law trends and tactics sure to shape 2023. This installment is one of 12 concise, field-specific podcast episodes that are part of our annual forecasting favorite, The Year Ahead. We invite you and others at your organization to experience the report's legislative, regulatory, and litigation insights in full at our website, jacksonlewis.com, or listen to the podcast series at whichever platform you turn to for compelling content.
How are you doing, Jackson Lewis podcast world? I'm Mike Jakowsky, an attorney in the New York City office, and I have with me my colleague and attorney from our White Plains office, Isaac Burker. Isaac and I are part of a team of attorneys that practice nationwide, counseling clients on reduction in force issues, and you're all very lucky today because we're going to spend our time together talking about reductions in force. Typically, I would say I probably do, depending on the season, 20 to 30% of my work in counseling clients on reductions in force. Lately, it is much higher than that. Isaac, how much would you say you're spending right now counseling clients on reductions in force?
A lot. I mean, I don't know about you, but this is probably the most busy I've been as far as reductions in force, plan closings, things like that since the beginning of the pandemic. And maybe the only difference is I feel like at the beginning of the pandemic, it was more like WARN-related closures, while now it's a lot more of these kind of large-scale restructurings and things like that I seem to be dealing with clients.
I think that's right. I don't remember the volume of reduction in force counseling being this high since, the 2008, 2009 period of time. So I think the difference between the COVID period of time and now is during the COVID period, most employers are making what they believe to be temporary decisions. What I'm seeing now from clients is more longer term, forward thinking decisions on how to adjust staffing levels. What's the most challenging thing you're dealing with right now?
It's always the same. It's dealing with remote workers because everyone's remote, and well, not everyone, but it's very rare that I, start working with a client and they say that, everyone's at the Smithtown facility and that's where the RIF is happening. I kind of want to jump up and down because I know it's going to be a potentially easier situation. But, when you're dealing with remote workers, it raises a whole bunch of different issues, be it for WARN purposes, for the purposes of determining what state law should be applicable, what laws need to be released, things like that. What about you, Mike?
I think it's clients operating on a very quick timeline, right? And not fully, I think, taking into consideration other than the budgetary need to reduce headcount into some of all the other items that go into it. So a lot of it is getting calls and saying on a Monday, saying we're doing this on a Thursday or Friday, and then trying to, slow the client down to think about, some of the different topics like, are you going to be doing severance agreements? And if you are, what are the state laws that apply for waivers, and or anything unique in that particular state that would limit your ability to, terminate those folks, whether it's WARN. And for those that aren't familiar with the topic, that's the Worker Adjustment Retraining Notification Act, which under certain circumstances requires advance notice to both government agencies, applicable unions, and impacted employees. And then walking through the client with the selection process, and walking the client through the WARN analysis, a disparate impact analysis, and then any back end, issues with releases or final pay requirements, but doing that in a very tight window. And then working with clients where they may have triggered the WARN Act and need to provide WARN notice and what to do in that circumstance.
Yeah. So you get a phone call from a client that says we're going to be closing this facility or we're going to be conducting this layoff. Where do you like to start with your conversations?
I'll generally start with, what else have you considered? Have you considered, salary freezes, hiring freezes, reductions in hours, furloughs, staggered shifts? I'll start with voluntary resignation programs. I'll go through the litany of things with clients that you may be able to do to avoid a reduction in force program. And then assuming they tell me, no, Mike, we're moving forward with reduction in force program, then I want to know whether or not there's going to be any outside limitations on that. So I'll ask, is there a collective bargaining agreement, and the numbers? I think the numbers, meaning the headcounts for individuals going, is going to be really crucial in, figuring out what's the structure within which we're going to operate. How about you?
Yeah, I think that's right. The first thing is trying to get a handle on, for one, making sure that there's not some other options that they haven't considered that are maybe either less drastic or less potentially fraught with risk than actually conducting, a full-scale layoff. And then, if once we find out, okay, this is the route we're going, I think usually the next thing we have to look at is trying to get our handle on the overall numbers to determine whether or not there's a potential WARN Act trigger, which, if there's a WARN trigger, you have to provide 60 days notice. Some places, like we're both in New York, you have to provide 90 days notice. And that's a lot of times that clients having to kind of put the brakes on their plans a bit.
I think that's right. I think a lot of times the challenge is in that short period of time figuring out whether or not we have a WARN event. Federal WARN is triggered if you have 50 full-time employees that are terminated at a single site as part of a mass layoff that constitutes 33% of that full-time workforce. So while that may seem simple, I think a lot of times I spend a good deal with clients figuring out who's full-time, because it's not how the company decides full-time. It's how WARN defines full-time, which is anyone that works more than 20 hours on average a week and has been employed for, more than 6 months, and then figuring out where the single site is. And then an additional way that WARN could be triggered is if there's a plant closing, which most, folks will jump to, the closure of a facility, but that could be the closure of an operating unit. And that's if there's 50 or more full-time employees being terminated as part of the closure. I think the biggest challenge is figuring out now where the site is. How do you work with a client on figuring out where the site is with remote workers?
That's the big issue. And I always start my conversations off with clients on that issue by saying, look, this could be a bit of a frustrating analysis. And I know you're coming to me for like definitive answers, but this is an issue where there kind of isn't a definitive answer. And you need to kind of figure out where remote employees report, where they're supervised from, and just kind of figure out an analysis for your company that seems to make sense, and then stick with it, and just recognize that any analysis you take, there's the potential that a plaintiff's attorney could find some outlier case to try to argue that the numbers should be cut a different way. And that's how I've been handling it. You?
Yeah, I think similarly, I'll recommend that the clients kind of cut the WARN analysis a couple different ways. Whether at the first level supervisor, second level supervisor, and then ultimately trying to report into a physical site to see whether or not there's a WARN triggering event. Assuming there is a WARN triggering event, then we get into complicated discussions with the client over, do they have time to provide the WARN notice? Which under the Federal WARN Act is 60 days advanced working days notice, or is there some other sort of creative option that may work, such as, a garden leave or a pay in lieu option, meaning you pay the employees instead of providing to them notice. It doesn't always work in every jurisdiction. And then you add in trying to figure out, once you figure out where the site is, then figuring out if there's a localized WARN Act that applies. I don't like calling them mini WARN Acts or baby WARN Acts, because most of the state WARN Acts now are more burdensome than the federal WARN Act. What are some of the more challenging states you see from a WARN perspective?
Well, certainly, New York is is very restrictive. For years now, you and I have both been telling clients, well, New Jersey passed these amendments, but then COVID hit and everything got put on the back burner, so don't worry about it. Unfortunately, they can't say that anymore. And the New Jersey amended WARN Act is going to be effective, I think, in April. And that's going to be the only WARN Act I'm aware of that actually requires severance pay, and has a fairly low triggering threshold. So those are two, of the more difficult WARN acts that I tend to deal with. Plus, and I guess California as well, because it's just there's multiple ways that it could be triggered that are a little tricky sometimes. What do you think?
I think that's right. And I think New York, New Jersey, Illinois, there's a number of Maryland, there's a number, and it's a growing list of states that become challenging from a state's perspective. But I think figuring out where the head counts are and whether or not you have a warrant trigger also then roll into your severance issues, because to the extent you're going to give severance to individuals, I think a lot of times you need to figure out what's due and owed to these employees. Because if you're owe these employees warrant notice or warrant notice pay, that could impact the amount of severance in many instances that you're able to provide to employees to obtain or secure releases. Because obviously there's a consideration issue, right? You need consideration to be able to get a release. So after I've walked them through the warrant piece, then I'll start with the less rigid, but more creative analysis of what's a program and what's a decisional unit under the Older Workers Benefit Protection Act and Age Discrimination and Employment Act, which, for those of you that may not be familiar, is a law that protects individuals who are age 40 or over and requires that employers provide 45 days to consider a release to those individuals, 7 days to revoke, and a host of disclosure information, such as, the job titles and ages of those selected who are as part of the program, as well as the job titles and ages of those who are not selected as in that selected individual decisional unit, as well as the selection criteria. I don't know about you, Isaac, but while warrant is a numbers game, the analysis of the program, decisional unit, and the selection criteria often takes a good bulk of the time. And sometimes if the decisions haven't been made, great, and we can work with the client to kind of shape the selection criteria, shape the decision units. But I'm finding oftentimes that the decisions have already been made, and we're trying to figure out what those are for pre-made decisions. I don't know about you.
Well, Mike, I don't know if you remember, this was this was maybe more than five. This was probably 7 or 8 years ago. You and I spent a couple days in the city. We were handling a big RIF with lots of different decision makers, and our task was to try to lots of different decision makers that didn't really understand the Older Worker Benefit Protection Act requirements, and I think didn't necessarily have time to deal with us. And we were tasked with trying to recreate, how the decisions were made. I remember that being a very painful, having some painful conversations there, trying to recreate what was going on there.
I vividly remember sitting in a room for many hours with you, talking to clients about decisional units. After a while, your voice became embedded in my head, but it is challenging. And in that situation, the client had the luxury of having some time to have us come in and, vet, the selection process. I know we're almost out of time, so just some other things for clients to consider and for employers to consider when conducting these reductions in force is obviously the warrant issue, the selection criteria and the selection process. But also I think you have to consider whether or not you have time to conduct a disparate impact analysis, which looks at the selection rate of individuals, determine whether or not there's any immigration issues. Folks on visas is being exited going to impact their ability to remain in this country. Benefits issues. Are there any vesting periods coming up? Or is anyone under an employment agreement? And then I think you can move into some of the more softer non-legal related issues. Is how are you going to communicate it? Are you going to engage a public relations firm? How are you going to approach both external and internal stakeholders on this issue? Am I missing anything, Isaac?
No, I think you touched on the main points. So the main takeaway that I hope people get from this is that if you're considering a reduction in force or a closure of a facility, it's best to try to involve, there's lots of considerations and there are issues that could really affect your timeline. And it's a good idea to involve an attorney with experience in the area early on in the process, so that you could get kind of get steered in the right direction, so you don't find yourself at the last minute scrambling with some of these different WARN and decisional unit issues. So Mike, thanks for chatting for a bit. I hope that the listeners found our conversation to be useful, and look out for more information in the year ahead.
Thank you for joining us for the Year Ahead 2023 Special Edition podcast series. Please tune in to the next episode, where we will continue to tell you not only what's legal, but what is effective. All of our Jackson Lewis podcasts are available to stream and subscribe on Apple Podcasts, Google Podcasts, Libsyn, Pandora, SoundCloud, Spotify, Stitcher, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.